We can start with rebuttals. Does anybody need to take a break at this time? If so, raise your hand. Nope? All right. Mr. Owens, you can go ahead and give your rebuttal argument whenever you're ready.
Thank you, Your Honor. Ladies and gentlemen, it's nice to see that Mr. Carlos and I do agree on some things. Mr. Winslow is presumed innocent to start. Mr. Winslow is presumed innocent as he sits there right now. Mr. Winslow is presumed innocent unless and until you 12, based upon the quality and the quantity of the evidence in this case, join together and find him guilty. And this is the moment that we trust you with that decision. That the public, the community, trusts you with that decision. And it is the people's position, undoubtedly, based upon not just the number of women that came forward, but based on what they actually said, what they've actually testified to here in court, that shows his guilt. This case has been proven beyond a reasonable doubt. And make no mistake that this defendant bears a propensity, a predisposition to commit the crimes that he's been charged with. That's what the law recognizes, and that's what the law requires you to consider. If you find beyond a reasonable doubt that he committed one of these enumerated offenses that we've talked about, then you can use that evidence to prove that he committed the others. And make no mistake, Mr. Carlos will stand here and he will attempt to chip away at extraneous fact after extraneous fact, things that don't go to the core of what actually happened, and try to convince you or persuade you that this case hasn't been proven. But ladies and gentlemen, don't let him pull the wool over your eyes. Kellen Winslow is a wolf in sheep's clothing. He has the name, he has the money, he has the fame. But who does he choose to victimize? Women who are unlikely to report, who are vulnerable out on the streets, who are unlikely to be believed if they come forward. That's what he did last spring. And now you, as members of the community with your own life experience, come in and you have to listen to what they have to say and make a decision. What was glaringly absent from Mr. Carlos's argument? He doesn't want to focus on what Mr. Winslow actually did, about what the testimony was of his actions, his threats to kill them, when he forcibly raped them. No, he's talking about other things. The confusion, the beating them down on cross-examination, the ultimate admission to, well, maybe I was menstruating, right? Is that a lie that then impacts her credibility to such an extent that you can't believe her, Jane Doe number one, when she says what he made her do? What does he do when he sets up his argument? He says, all right, bird's eye view, aerial camera. You're watching this happen. It's a movie with no sound. Set aside what actually happened and look at it through this prism of doubt. Now, what Mr. Carlos did is he's attempting to misapply the actual jury instructions. He keeps arguing from the very outset that this is all circumstantial evidence, that there are two reasonable conclusions from this. But that's not what the law says, and that's not what the judge instructed you on yesterday. There are two forms of evidence: direct evidence and circumstantial evidence. Direct evidence is the testimony of the witnesses. That can prove any fact. When a woman stands here and says that I did not consent to the sexual acts that he forced on me, that when he threatened to kill me, I was fearful, and that's why he did what he did, that is direct evidence of his guilt. There is no reasonable inference to be drawn other than whether or not that's true. He is attempting to get you to believe that the law somehow requires you to find him innocent based upon direct evidence. And that's not what the law says. Circumstantial evidence is the type of testimony or the type of evidence that comes forward that allows you to infer the truth of what's being said. And ladies and gentlemen, when you do have woman after woman after woman coming in and testifying to those core true facts of what he had done to her, to each one of them, that is the circumstantial evidence that confirms and corroborates what the others have said. There is nothing in the law that requires you to put each individual case in its own separate silo. Put it over in this box and then consider it separately from this box or this box and this box and this box.
Objection.
Because why?
Just a minute, what's the objection?
States the law.
Overruled, I'll let him finish, go ahead.
Thank you, Your Honor. Because why else would you be the jurors sitting here listening to all of the evidence? All of the evidence that came forward in this trial can be considered by you in determining his guilt for each one of these 12 charged crimes. And don't believe him when he says it, that you gotta separate it all out. Yes, this case must be proven beyond a reasonable doubt for each individual charge for you to convict him, certainly. But in terms of your consideration of the evidence, do not lose sight of the forest through the trees. That's what he wants you to do. Well, if you focus on this tree here or that tree there, then you're not gonna see the big picture. Reject that. That's unreasonable. That's the exact unreasonable defense theory that I was warning you of. And that's what he's trying to get you to buy. Don't do it. So Jane Doe number 5 must have been mistaken. She didn't see what she saw, and he didn't say to her what he said to her, right? Was she mistaken when she heard him say the words, "Do you see this? Do you like that?" Was she mistaken when she saw his penis erect, protruding from his pants? This was all just a big mistake? You heard from Jane Doe number 5, who explained when it was that she and her husband found out who he was. It's when Brad Moser talked to her about it, right? That was before Officer Pacheco was there. And Officer Pacheco took down her report and included in quotes that, yeah, at that point when they were talking to her, they knew that he was a football player, a tight end, right? But they told you from the witness stand when it was that they learned that. That, yeah, they had seen a prior news report, months past, as she said, but that was in the back recesses of her mind. When he did what he did to her in the Crunch Fitness, she didn't recall that. She didn't recognize him. Was she lying? Was she being dishonest? Was that not an authentic, believable response when she was testifying? I didn't know who he was until after. And yet now Mr. Carlos is trying to say that Officer Pacheco, talking to her the following night, said, well, they knew it from the start. That is her inference based upon a report that she wrote down while working 4 p.m. to 4 a.m. and being asked to take a report from these people. Sergeant Emick, Jane Doe number 4. What's the actual evidence of how that statement was documented? Make no mistake about it. Sergeant Emick is experienced. Sergeant Emick does supervise within the Major Crimes Division, one of the units being the sexual assault unit. He was not directly involved in the investigations, as he said. His detectives were directly involved in the investigations. That a protocol had been set up so that he would screen incoming calls and would provide the information for the district attorney investigators to follow up on it. Ladies and gentlemen, he took a phone report, unrecorded, no notes as he testified. He sat there and said, nope, no notes. He called me to let me know that there was an additional victim coming forward. I asked him to document it. This is what he testified to. You recall it was just last Thursday. And an hour and a half later, after he had taken the information, he writes an email. After he writes an email, a report's requested, and he writes that 2 months later. Ladies and gentlemen, taking a phone report from a victim of a sex assault, whether it was the day it happened or 15 years before, 15 years after it happened, that's a difficult thing to do when they're in a traumatic state. What do we actually have documented and recorded? A lengthy 3-hour interview where we sat down with her in her own home, listening to all the facts and details that she could recall, and then the testimony that she's been able to provide based on her clear recollection of the events. Now, Sergeant Emig did what he could in order to try to accurately recall what was said in the conversation. But ladies and gentlemen, it's clear that he was misinterpreting what she said. There was a car ride, there were multiple people present, Mr. Winslow was raping her, and that she had drank that night. All of those facts are the same. Whether Sergeant Emig was able to accurately reflect what was said to him in that phone conversation does not create reasonable doubt. Jane Doe number 4's compelling, honest, authentic testimony before you proves his guilt beyond a reasonable doubt. And when Nicole Edwards is trying to recall 15 years prior what she was present for, what she recalled, she does misremember which night this happened. She does recall being in a house when Mr. Winslow was there. She does recall Jane Doe number 4 coming down upset. She does recall Jane Doe number 4 telling her that she had been assaulted. She does recall a drive in a car where Jane Doe number 4 was crying. She was upset. She was distraught. Who's the person who's going to remember the details? The rape victim. Who's going to know what actually happened on the 2 interactions she had with this man? Not her friend who's being asked about it 16 years later. Her. Was she lying to you based on some motive? Based on some incentive to try to really get this guy that she hadn't had any interaction with for the last 15 years? That's unreasonable, and you can reject that argument. Mr. Carlos is attempting to get you to look at every single individual case and any small inconsistency and create reasonable doubt, when in reality, everything is corroborated through the core facts of what each woman has testified to. Mr. Carlos claims that Jane Doe number 3 is a law enforcement creation of what happened, that it couldn't have been Mr. Winslow. And he gives short shrift to the way that we've actually proven that he was there. He says that there's nothing to suggest that he was in her driveway the day before the indecent exposure incident. You saw the GPS data. And then you saw where his route started the following day, when he clicked record on that Strava application on his phone and rode away from the scene of the crime. You also saw that this is what he would do regularly. He would be riding his bicycle in that area. He committed this crime, make no mistake. If it's an identity case, that's easy. You can find him guilty of that. Jane Doe number 2. What did the Strava application show you? You have Mr. Sesma taking a short 1-minute ride down Manchester on a Wednesday afternoon at 1:30, beginning at the community college and ending at a red light on the northbound on-ramp to the 5 freeway. Cars passing by as he does so. What does the Strava application show that Mr. Winslow did 3 days before he took Jane Doe number 2 on Mother's Day, down Manchester Road to a dirt shoulder with no lights around. He rode all the way down Manchester, along that route that Mr. Sesma took, but continued on past the 5 freeway to that area near the San Elijo Lagoon Preserve. As you heard the testimony from Mr. Sesma, there are no streetlights out there. And as you can see from the maps that have been introduced into evidence, Mr. Winslow was familiar with that area. He knew where to take her. And he did. If Jane Doe number 2 was making up this rape, why didn't she say it happened under a bridge? Why didn't she say it happened out in Ramona? It happened there, on Manchester and Encinitas, just like she said it did. And you've heard no evidence whatsoever that she consented to the acts. Notice the gloss over that fact. The absence of evidence presented by the defense to show that she consented should immediately cause you to be suspect of the way he's argued that case.
All right, just know, the court's going to interpose its own objection. The jury will disregard the last comment by Mr. Owens. That portion of his argument will be stricken from the record. All right, you can go ahead, Mr. Owens.
Thank you, Your Honor. Ladies and gentlemen, Jane Doe number 2 has come forward. She was consistent when she was interviewed by Deputy Latonio, Detective Moses, Ann Williams, Detective Johnson, when she testified at the preliminary hearing, and when she testified before all of you. Not once has she ever even implied that this was in any way anything but a non-consensual rape. During the cross-examination of Jane Doe number 2, there was nothing presented by defense counsel that could lead you to make a reasonable inference that this was consensual.
Same objection, Your Honor.
Overruled. He's commenting on the cross-examination of Jane Doe number 2. That is proper argument and will be allowed. You can continue, Mr. Owens.
Thank you, Your Honor. Ladies and gentlemen, this was not consensual. Jane Doe number 1 was beaten down by Mr. Carlos. He just acknowledged it. He said that he doesn't take pleasure in doing it, and yet he laughs at her when he talks about what she said. When she ended up being walked down that road where she started to contradict herself, yes, that's skillful cross-examination, but it's an unsophisticated victim. We do take them as they are. You take them as they are. And you have to listen to the core facts of what's being said, what's being testified to. And what is it that he focused on? He focused on exactly what I told you he would. The peripheral facts, the extraneous facts. Menstruation or not. Alcoholism or not. Ladies and gentlemen, never, not once, did she say that he didn't threaten her. There's zero evidence whatsoever that there was any sort of, quote, transaction. That's based on speculation, implication, and innuendo by an attorney representing a criminal defendant. There's no actual evidence of that whatsoever from any one of the witnesses who have testified. You can reject it as unreasonable. Now, in terms of your decision now, your consideration of all of the evidence that's been presented to you, when you look at the totality of the testimony, when you think about how it is that this case has come to be, how it's been brought before you, and what was actually said from the witness stand, there is no doubt that this defendant bears a sexual predisposition to commit the crimes that he's been charged of. He criticizes me for using labels. What else is it other than sexual deviancy? What else is it other than a sexually violent predator who's preying upon the perfect women? People that society has ignored? A drunk teenager who's kept a secret for 15 years? A homeless woman who lives at the transit center? A woman who has very little, almost no family support, save for her daughter coming forward. A woman who's battled alcoholism her entire life, as she told you. And a woman who was raped by this man against her will. Jane Doe number 3 and Jane Doe number 5 prove that he is a sexually deviant individual. All of it, when you look at it in sum, proves that he is what I've said he is. And all of it proves that he committed these crimes. You do have the power and the privilege to hold Mr. Winslow accountable for what he's done. You have a responsibility to look at the evidence carefully and discuss it amongst yourselves to ensure that every single one of you agrees that he's committed each one of these crimes. But follow the law, ladies and gentlemen, not the argument of counsel. I'm confident that each one of you will get together, discuss this, deliberate, and render a true and just verdict. There is only one reasonable conclusion here. This defendant is guilty of all 12 counts. Come together in one voice and find him guilty. Thank you.
All right, thank you, Mr. Owens. Can you take down the PowerPoint slide as well? All right, thank you.